Indian Liberal Group Bangalore chapter extend a hearty welcome to the two legal luminaries, jurists and acknowledged experts of constitutional law of our country occupying the dais and all those present in this hall. Dr. B V Acharya was born on 1933 in Belpu village of Udupi Taluk. He had his education in Bangalore and obtained his BA degree from Madras University in 1954 from St. Aloysius College, Bengaluru. He obtained his law degree from Madras Law College in 1956 and enrolled as an advocate on 29/8/1957. He did his apprenticeship in the chambers of Sri Gangadhar Das, a leading advocate of Bengaluru, and that set up his own independent practice in Bengaluru. In recognition of his honesty, erudition, and skill in advocacy, he was appointed as an additional public prosecutor at Bengaluru for 4 years from 1961 to 1965 and then as district government pleader Dakshin Kannada district for 5 years. Dr. Acharya shifted his practice in Bengaluru, principally concentrating his work in the High Court, and was designated as a senior advocate by the High Court of Karnataka during May 1989. He held the prestigious post of Advocate General of Karnataka for 3 terms. First for about 1 year in 1989, second for about 2 years from December 1992, and finally from October 2007 to May 2008. He has appeared as special public prosecutor in several sensational cases. Dr. Acharya was elected as a member of the State Bar Council between 1973 and 1982 and was elected as chairman of the Karnataka State Bar Council from 1979 to 1982, during which period he was closely associated in the establishment of the premier National Law School of India at Bengaluru. Dr. Acharya has attended many law conferences in India and abroad and has studied the legal systems of USA, some European countries and China. In January 2009, the Bengaluru University conferred on him honorary doctorate in recognition of his legal erudition. Dr. Acharya will be speaking on judicial activism and public interest litigation, a topical and difficult subject enlightening every one of us. Dr. Bhaktavatsala was born on 12/1952 at Bangalore and obtained his BCom degree from St. Joseph College and law degree from Bangalore University through SJR College, Bangalore. He has obtained his master's degree in constitutional and administrative law from the University Law College, Nagpur. Dr. Bhaktavatsala enrolled as an advocate on 9/1/1980 and soon made his mark in the profession. In 1988, he was selected and appointed as a district judge and has served in the districts of Gulbarga, Mandya and Belgaum, and finally as secretary to the government in the law department. On 18/4/2002, he was elevated as a judge of the Karnataka High Court, in which capacity is still functioning. Even with his busy schedule as a judge of the High Court, he has submitted his thesis on the constitutional developments in India through judicial process to the National Law School of India, University, Bangalore, which has conferred on him Doctor of Philosophy. He is still pursuing his academic activities and has registered for Doctor of Laws program on the topic Administration of Justice and Justice Delivery System in India. I am sure he will be successful in his pursuit and benefit our legal system. With these few words, I request Dr. Bhaktavatsala to proceed over the function and conduct the proceeding. Thank you, friends. Right, Dr. Acharya.
Honorable Justice Dr. Bhaktavatsala and my friends, I wish to start my talk by giving my respect to late Sri D V Gundappa, who is the founder of this great institute, which is rendering such yeoman service to the public. Secondly, I wish to say that I consider it a great honor on me to give me an opportunity to speak to an elite audience like you on this topic, and I am really grateful to Honorable Justice Putswamy for giving me this opportunity. I also thank him for saying very nice things about me. Anybody feels happy to be flattered, particularly special when it is in the presence of my wife. He specially invited her to be present here today. Therefore, I must extend a special thanks to him for that purpose. Now, according to me, judges are always requested to deliver speeches, and they deliver learned speeches, no doubt about it, but it is very rarely that a lawyer is asked to deliver a speech, because in society, at least a section, though it is said to be a noble profession, some people always cut jokes about lawyers as if they are unwanted evil in society. In fact, when I joined the law college on the very first day, my professor narrated a story that there was a boundary dispute between heaven and hell, and as we have even now, boundary disputes are common, and it was decided that each will send two lawyers from either side to argue before the administrator, and there was so much of rush from hell, so many contenders claiming that they have won so many cases, therefore they are most eligible. Ultimately they found there was no application from heaven, so the selection committee went there to search, and they found there was not a single one available, and therefore the heaven had to lose the case. This is how we are sometimes looked upon. But anyway, I am grateful to all the organizers for giving me as a lawyer an opportunity to address you. Now, coming to the subject, judicial activism, with which I will deal first before I say something about the public interest litigation. Now, under the Indian Constitution, the powers and functions of the three different organs of the state, namely legislature, executive and judiciary, are defined, though the doctrine of separation of powers has not been accepted with full rigidity, because in some small areas there will be overlapping. For instance, the executive performs a legislative function when it promulgates an ordinance. Similarly, the executive may also perform some judicial or quasi-judicial functions within the permissible limits of law. So, there is no definite rigidity, but still the three organs have to function within the area earmarked for them, and one is not expected to trench upon the area which is reserved for the other two wings of the government. That way, all the three wings, legislature, executive and the judiciary, they are all equal under the Constitution. They are creatures of the Constitution. But all the same, the judiciary holds a very unique position. The task of seeing that the other two organs of the state act within their sphere and they do not cross their limits is also entrusted on the judiciary. Judicial review is a basic feature of the Constitution, and that makes the judiciary in our country most powerful institution. If today the legislature does something unconstitutional or wrong, that legislation can be stayed and struck down by the courts immediately. Similarly, if there is an executive action which is contrary to law or unconstitutional, the courts have the power to strike down, and before they strike down, to grant an order of stay. So the effect of any excessive action by these two wings can be halted by the judiciary. But you cannot say the same thing if the judiciary itself does something wrong. Of course, if it is the lower courts, you may approach the Supreme Court. But if the Supreme Court itself does something which according to the other two organs are beyond their power, then the remedy is not available immediately. Of course, technically you may say in the next election you can bring about change and all that, but it is a long process. What I wish to say is, while the judiciary can strike down the action of the executive and the legislature immediately, there is no remedy if the judiciary does it. Therefore, both the Supreme Court of India as well as the Supreme Court of United States have said that self-restraint by the judiciary is the most important thing. In fact, Justice Stone of the Supreme Court of United States says, while unconstitutional exercise of power by the executive and the legislative branches of the government is subject to judicial restraint, the only check upon our exercise of power is our own sense of self-restraint. Now, bearing these principles in mind, let us examine the role of the judiciary and its functions with special reference to what is known as judicial activism. Now, what is judicial activism? It is not defined anywhere. It is not traceable to any law or statute. Judges themselves have given different meaning to this expression. It does not mean same thing to all the judges. Broadly, this expression is used in two senses. In the first sense, what it means is the judges by this judicial activism perform only their constitutional obligations by interpreting the laws in the context of changed situation to meet the need of the present day challenges, if necessary, even by eschewing an outdated meaning given in the past. In the other sense, that is the second sense, it means that the judiciary has to act and respond when the legislature or the executive becomes inactive and fail to discharge their constitutional obligations. In such a situation, what should be the response of the judiciary? Should it say it is the duty of the other organ and I have nothing to do with it? Or should it be creative and fill up the vacuum? The simple answer, according to many, is that the judiciary must respond. So this is the second meaning, that is failure of the other two wings to perform their functions. Then can the judiciary step in and fill the gap is the question. On this, there is no unanimity, there is controversy. I will come to it later. Now, first I will deal with the first meaning which has been given. That is, the judges must interpret the law. They should be creative and imaginative, and though the provision which they are interpreting has been enacted long back, today it may be necessary to give new meaning to the very expression by giving such a new interpretation in the context of present day social needs. If necessary, you deliver justice to the party. This is the broad outline where they say it is that is called judicial activism. You merely don't depend upon old precedents and say, this is the definition given long back, I will follow it. No, I will consider the whole expression in the context of present day need and then give your judgment. That is the broad aspect, and they say this is a question of creativity, and the courts must see that new principles of law are evolved, new meanings are given to the very expressions used earlier, and thus you give justice to the party. This is the first. Now, defending this judicial activism in this sense, and in defense of it, I think almost all judges are unanimous that there is no harm in having this sort of judicial activism. Not only there is no harm, it is necessary for the purpose of proper administration of justice, for survival of democracy. It is necessary. There is hardly any judge who said, no, I will be only conservative, I will not bother about the new dimension to the law or create any new principle of law. No judge ever says that. But still, in defense of this, what some eminent judges have said, I will just quote one or two things. Using the expression in this first sense and advocating judicial activism in this sense, Justice Dr. A.S. Anand, former Chief Justice of India, says thus: evolving new juristic principles for the development and growth of law is an accepted and well-recognized role of the judiciary, not only in this country, but in almost all common law countries. The function of the higher courts in the country has not been limited to exploring what the constitution makers meant when they wrote these words, but also to develop and adopt the law so as to meet the challenges of contemporary problems of the society and respond to the needs of the society. The Constitution cannot be a living and dynamic instrument if it lives in the past only and does not address the present and the future. This exercise of jurisdiction by the courts in India has been criticized by some as judicial activism indulged in by non-elected judges who upset the decision of the elected representatives of the people, unquote. To a question as to how he has seen the functioning of judicial activism in this country, Justice J.S. Verma, former Chief Justice of India, replied thus, I quote, the judiciary will continue to respond to the changing needs of the time. That is how activism has evolved. Let me dispel the popular impression that judicial activity began less than 2 decades ago. The truth is, way back in 1893, Justice Mahmood of the Allahabad High Court delivered a dissenting judgment which sowed the seed of activism in India. It was a case of an under trial who could not afford to engage a lawyer. So the question was whether the court could decide his case by merely looking at his papers. Mahmood held there is a precondition of the case being heard. The word used is heard, and as opposed to merely being read, would be fulfilled only when somebody speaks. Just what he said is, if he has no lawyer, at least he must be heard. Unless someone is heard, it will not be decision of a case after being heard. Just look at how that man treated the law as a living organism. That is the spirit in which judges engage in activism even today, unquote. Late Sri M.K. Nambiar, one of the very eminent jurists of our country, says in his treatise, Distribution of Powers, I quote, "The function of interpretation is to adopt the static text of the Constitution to the dynamic needs of a changing community," unquote. The Supreme Court and the High Courts in India have earned a reputation for creativity and ingenuity in the development and adoption of common law to the contemporary problems and opportunities. Now I will just quote only few instances. It can never be exhaustive. Only few instances to show how judicial activism has been exercised by the courts in India in this first sense, that is giving new and proper interpretation. The first is the very topic of amendment of the Constitution. Now in Keshavananda Bharati, the question arose, what does amendment mean? What is the power? To what extent the Parliament has the power to amend the Constitution? Now in the normal course we would have said, amend means bring about whatever changes you want. You delete that para, you add this para, you delete one section, add another section, you can do anything. But then the Supreme Court, in its wisdom, in a dynamic way, gave it a new meaning. They said amendment can mean amend anything but not destroy. Power of amendment does not give you the power to destroy. Therefore, the Constitution, whatever be the basic features of the Constitution, you cannot touch. What you can amend is only the other details. The result is, today we have the Constitution with many amendments, but still we have the original Constitution. But for this interpretation, probably the politicians would have amended the Constitution to such an extent, today it would have been an entirely different Constitution. Now this is the great method by which the Supreme Court saw to it that the basic features of the Constitution is maintained. Democracy, secularism, power of judicial review, these are all held to be the basic features of the Constitution. The list is not exhaustive. In every case, in future, even if there is an amendment, the courts have the power to say whether it touches the basic feature or not. So this is how our Supreme Court has interpreted the word amend. Now the second instance which I can give is about Article 14. Article 14, as it is, merely says classification, equal protection of the laws, and so on. It is only a question of classification on a rational basis, and that must have the nexus with the object to be achieved. That is how it was initially interpreted, but then the courts in India gave a new dimension to this very Article 14. They said anything that is not just and fair will be arbitrary, and the same is liable to be struck down. In 1950, A.K. Gopalan's case, they said procedure established by law means the law made by the Parliament, nothing beyond that. That is the old concept. But with the changing times, they said the procedure on which you rely should be just, fair and reasonable. And if it is not just, fair and reasonable, the court can strike down that. This is the new dimension given to Article 14. Any action which is arbitrary, the courts have a power to strike down. This is how, if you call it a case of judicial activism by interpreting the law. And the third illustration I give, and this is the most important one, is interpretation of Article 21 of the Constitution. Article 21 merely says no person will be deprived of his life except by due procedure established by law. Now, if you literally take that word, it only means you can't take away the life of a man because he has a right to live unless in accordance with procedure established by law. This was the plain interpretation that could have been placed, and sometimes it was placed. Even that right, as you all know, during emergency, we did not have even that right. Because all the fundamental rights got suspended, and the Attorney General replied to the court, said, if a man is shot dead point blank, he said, yes, it can be done. He has no guarantee because the fundamental right is suspended. This is what they said. Even this right we did not have. But fortunately for us, in those days, our high courts came to the rescue of the citizens. It should be said to the credit of the high courts in our country that they upheld the rights of a citizen, though in that particular context, the Supreme Court failed. This is another instance. There are so many instances how the judges, by interpreting the law, have given the relief to the parties. Now, in fact, on this Article 21, the Supreme Court has been consistently expanding the dimension of Article 21, right to life and personal liberty, within the bounds of law for purposeful interpretation. 30 years ago, in F.C. Mullin versus Administrator, Union Territory, 1981, 1 SAR 1516, Justice Bhagavati observed thus, quote, the right to life includes the right to live with human dignity and all that goes along with it, namely the bare necessities of life as adequate nutrition, clothing and shelter, and facilities for reading, writing and expressing oneself in diverse forms, freely moving about and mixing and commingling with fellow human beings. The magnitude and content of the components of this right would depend upon the extent of economic development of the country, but it must, in any view of the matter, include right to basic necessities of life and also the right to carry on such functions and activities as constitute the bare minimum expression of human self. Every act which offends against or impairs human dignity would constitute deprivation pro tanto of this right to live, and it would have to be in accordance with reasonable, fair and just procedure established by law, which stands the test of other fundamental rights. In Bandi, unquote, in Bandhumukti Morcha case, 84 Supreme Court, the Supreme Court reiterated once again the right to life guaranteed by Article 21 included the right to live with human dignity free from exploitation, and all the present day environmental laws and interpretation relating to environment all flow from this right. Right to life includes to live in a good environment free from pollution, and all the things that go along with it is the development of the law based on this Article 21, that is right to live. Right to live includes to live a healthy life free from pollution, from environmental degradation and so many other things. That is how the Supreme Court has interpreted this very article. Now, judicial activism in the above sense, it is not only not objectionable but also necessary for evolvement evolution of the law. This is what I say on the first aspect. The second one, which I said is a bit controversial, is, but one thing, before going into the second, I would like to say one thing. While it is permissible for the courts to interpret the law within the known and accepted canons of interpretation, in the process of interpretation, you cannot misinterpret it to such an extent as to create a new law. Now, this has not happened in many cases, but there is at least one important case which, according to me, I don't know whether Justice Bhattavatsala will agree with me. Anyway, law is a subject where you can't say everybody will agree every time. No, unlike mathematics, in law we do differ. Now, one instance which, according to me, this misinterpretation has taken place is in what is popularly known as second judge's case, that pertains to selection and appointment of judges to the High Courts and the Supreme Court. Till 1993, the first judge's case held the field, and the Constitution itself unmistakably gives this power of selection and appointment both to the executive and the judiciary. And it says President shall appoint. President shall means it is the executive on the aid and advice of the Council of Ministers, on consultation with Chief Justice of India and such other judges of the Supreme Court as the President may deem proper. Now, till then, there was process of consultation between the executive and the judiciary, and the last word remained with the executive. But in this judge's case, for the first time, the Supreme Court, interpreting these provisions, said the final word is with the Chief Justice of India. Chief Justice of India has the primacy, and they also evolved a new law which is not found in the Constitution. In the case of High Court, the Chief Justice and two senior most judges, they constitute a collegium, and what that collegium decides is the final word. The government is bound to accept the recommendation. With this, the executive is virtually deprived of its role in the matter of appointment. It had to do only the ministerial work. So this is how, and in the case of Supreme Court, they said instead of collegium of 3, it will be a collegium of 5. Now, none of these are found in the Constitution. This is a case where 9 judges of the Supreme Court gave judgment, and I may say that I had the privilege of addressing the Constitution bench for about an hour on these aspects of the matter, and this is the one judgment which, according to me, is a case of interpretation by which you deprive one organ of the state of its power and clutch at that jurisdiction which is not correct. Now, the Honorable Justice Verma, who spoke for the majority, himself has now conceded that they interpreted it in this manner with very good intentions, because they thought by this political interference in selection of judges will be eliminated. It's a very good idea, but unfortunately it did not. The quality of selection, according to my humble opinion, did not improve after 1993. The position earlier was better. Therefore, today, among the jurists, all are unanimous that these articles relating to selection and appointment of judges must go, and there should be a National Judicial Commission appointed, in which both the executive and the judiciary, as also the bar, must have a role to play. Now, this is the unanimous view of the Constitution Review Committee, presided over by Justice M.N. Venkatachalaya, former CJI. This is also the view expressed in the report, second Administrative Reforms Committee report, headed by Sri Veerap Moili, who is presently the law minister. He has even indicated the composition of this judicial commission, which should be presided over by the Vice President of India, in which both the executive and the judiciary must have a role. This is how I am giving this as only an instance to show, though judicial activism, in the sense that you interpret the law properly depending on changing needs, is right. This sort of interpretation is not proper and it is objectionable. Now the second one is, the second sense. Here what you say is the legislature fails to legislate. Executive exceeds its power and does some act which is unconstitutional. And it becomes necessary for the judges to intervene. What is the role? Can you trench upon their power and do it? Supposing there is no law, can you make a law, which is the exclusive privilege of the legislature? Can you give a direction, you do this executive act, which is within the province of the executive, what should be done? Now, divergent views on this. One view is, according to the other sense, judiciary is constrained to act when the organs of the state fail to perform constitutional obligations. It is in this sense the judiciary is expected to fill the vacuum created by inaction on the part of the legislature. According to one judge, the judicial activism has to play its role when there is a gap between law and justice. Now, in a lighter vein, I may not be mistaken, one judge said, put it very briefly, when do you act? Legislature fails, executive acts. He said, whenever there is legislative impotency and executive arrogance, then the need for judicial activism comes. When they fail to act, we must come. Now, criticizing those who say that you can't trespass upon the field of the other, Mr. Soli Sorabji, former Attorney General of India, says thus, quote, indignant critics forget that it is the executive's failure to perform its duty and the notorious tardiness of legislatures that impels judicial activism and provides its motivation and legitimacy. When gross violation of human rights are brought to its notice, judiciary cannot procrastinate, it must respond, unquote. Honorable Justice Michael Kirby, a judge of the High Court of Australia, which is equivalent to our Supreme Court, he justifies judicial activism in the following terms. The law abhors a vacuum. Into vacuum left by the failure of the other branches of the government to respond to urgent legal and social needs, the courts have sometimes stepped. Whether this is good thing or wise, or fraught with peril and positively damaging to the judicial institution, are questions exclusively for Indians to judge, unquote. Then as against this, where they say judiciary can't keep quiet, it must, if necessary, even trench upon the organ and give relief. As against this, Justice R.S. Pathak, when he was the judge of the Supreme Court, later he became the Chief Justice. In 1984, this is his note of caution, I quote, in most cases the jurisdiction of the court is invoked when a default occurs in executive administration and sometimes where a void in community life remains unfulfilled by legislative action. The resulting public grievance finds expression through social action groups which consider the court an appropriate forum for removing deficiencies. Indeed, the citizen seems to find it more convenient to apply to the court for vindication of constitutional rights than appeal to the executive or legislative organ of the state. In the process of correcting executive error or removing legislative omission, the court can so easily find itself involved in the policy making of a quality and to a degree characteristic of political authority, and indeed run the risk of being mistaken for one. An excessive political role identifiable with political governance, betrays the court into functions alien to its fundamental character and tends to destroy the delicate balance envisaged in our constitutional system between its three basic institutions. He strikes a note of caution and says, our trenching into the, or encroaching upon the field is not correct because it will all involve political decisions and we should not enter upon that. The following are some of the instances where the judiciary has performed its legislative functions. I am not giving all the details, just a few instances how the courts have gone to legislate. First, which comes to my mind is Unnikrishnan's case in 1993. The courts said in the matter of higher education, so many bad things are happening. One is a poor student unable to go, meritorious. Another is a rich student, not meritorious, but has lot of money. He can pay capitation fee. What should happen? They evolved a scheme. Of course, it is all done with good intention. They said 50% will be payment seat, 50% will be free seats. The payment seat candidate student will pay not only for his, but also for the other free seats. And like that, so many clauses. It is a law made by them. And then, having framed the scheme, and then they found the court flooded with petitions seeking modification because this is a scheme, even if it is totally violative Article 14 or anything, you can't go to court except the Supreme Court because it is a law made by the Supreme Court. Can you do it? The question is, you can. Ultimately, after about 10-15 years after having entertained any number of petitions seeking interim directions, interim change of the scheme and all that, ultimately the Supreme Court gave up the whole exercise and left it to the legislature. This is one instance where the courts went on to legislate with good intention. Similarly, regarding the Vishaka case, that is a provision for dealing with people who suffer sexual harassment at working place. There is no law. The judges were very angry that the legislature is not intervening. Therefore, they said this will be the law till the legislature steps in. That is another instance of making law with all good intentions, but clearly by encroaching upon the field reserved for the legislature. And the third one I say is about the service conditions of judges. Even here, it is all no doubt done with good intentions. What is the age of retirement? What should be the facility provided to? Judiciary requires utmost attention. All facilities, absolutely, there can be no question about it. But the question is one of the Supreme Court itself has said this is wrong, where our making law is wrong. This is I am just giving the instances where the courts did enter into the legislative. Similarly, the executive action where they have gone. Now, a direction to build a 5-story building for the Bar Association. It may be done with good intention, judiciary includes lawyers and all that, but still we find it is not proper. The government may have its own priorities, whether a hospital should get priority or a Bar Association building. It is not for the court to say. Similarly, direction regarding alignment of road. We find hundreds of petitions where the headquarters of the Western Railway should remain, Northwestern Railway or Southwestern, I don't know, whether it should be Hubli or Bengaluru. The decision of the government was quashed by the High Court, but luckily Supreme Court intervened and came down heavily on the High Court, saying that this is none of our functions. Why should you interfere with these matters? In fact, I appealed for the railways 2 days before the Prime Minister was to inaugurate the headquarters at Hubli. The Honorable High Court granted a stay and the whole proceeding had to be abandoned. Now, these are some, I am just giving some instances where the legislature and executive functions are being taken over by the courts. It is my considered opinion that as long as the judges granted relief to a citizen by interpreting law, taking note of present-day social needs, there cannot be any objection for such judicial activism. However, if by judicial activism they mean that they are entitled to usurp the functions of other two organs of the state, the same is highly objectionable, as the same is likely to result in tilting the balance of power provided for in the Constitution. In fact, the Supreme Court itself very recently felt that it has overstepped its limits in the matter of enacting laws and has referred the question to a larger bench for decision in the case of University of Kerala versus Council of Principals of Colleges of Kerala, reported in 2010, 1 SCC page 353, decided on 11/11/2009. In that case, the Supreme Court gave an interim direction for implementation of the report of a committee constituted by it, which according to the Supreme Court amounted to legislation by itself. One of the two learned judges of the Supreme Court had their own reservations as to whether it is legally permissible for the Supreme Court to do so. After referring to some of the cases where the Supreme Court felt that the judiciary was not entitled to legislate even when there was a pressing social need. In fact, the Supreme Court specifically refers to this Vishaka's case. They said it's a good thing about sexual harassment, your law, but it was beyond our competence. Having stated all that, they said the division bench referred 6 questions for authoritative pronouncement. Of them, 3 are most relevant for our purpose. I'll just read them. I'll quote, whether under our constitution the judiciary can legislate, and if so, what is the permissible limits of judicial legislation? Will judicial legislation not violate the principle of separation of powers broadly envisaged by our constitution? 4. Whether the judiciary can legislate when in its opinion there is pressing social problem of public interest, or it can only make recommendation to the legislature or the authority concerned in this connection. Now, what is the scope of Article 141 and 142 of the Constitution? Do they permit the judiciary to legislate and or perform functions of the executive wing of the state? Now, Article 141 says, what is the law declared by the Supreme Court shall be binding on all courts and tribunals within the country. 142 says, the power, there is inherent power in the Supreme Court to do anything, to do complete justice between the parties. Now, do these provisions, because in many cases they say, what we have said above shall be treated as law under Article 141 till a suitable legislation is made. And that is how they say whether this gives you the power to legislate. I hope the Supreme Court in the near future will go into this question and give a authoritative pronouncement on whether it is permissible for the courts or the judiciary to trench upon the area covered for others. Now, coming to the question of public interest litigation, with which I will deal very briefly. As you know, the old traditional litigation was a court will grant relief only to a aggrieved party. First thing when he enters the court, they say, what is your locus standi? How are you aggrieved by this order? That was the scheme. Though in CPC as well as Criminal Procedure Code, here and there are some instances where there may be scope for other reason also. For instance, Section 190 of the Criminal Procedure Code, while taking cognizance of an offence on a complaint or police report, third one is on information received by the magistrate. So anybody can go and give information. So also Section 133 of the Criminal Procedure Code, which gives power to the magistrate to pass suitable orders where there is a public nuisance, where your path is suddenly blocked, where a section of the people are affected, the magistrate has been given power, and that litigation will be one on behalf of the people of the resident and not a single individual. Similarly, Order 1, Rule 8, which says you apply to the court to say that this is on behalf of the public, so that they can come and either support or oppose. These are some exceptions, but broadly locus standi. But slowly the courts started diluting this procedure and said, expanded the scope of the people who could come to court. Even a man living in one ward could challenge an illegal action which is taking place in some other area. A ratepayer can challenge the action of the corporation or the municipality. Now it was expanded. Then came this public interest litigation. Any individual or organization can approach the court for redressal of a grievance if that is in the interest of the public. The primary question is public interest. If public interest is involved, then even if a proper petition is not filed, even if a letter is written, you say, somebody writes a letter saying that in the prison, the prisoners are being blinded and so many atrocities are committed and all that. Now, because the courts, in fact, this PIL or public interest litigation is one limb of judicial activism. By this they said, we will give relief to the members of the public, though the aggrieved can't come. Now a party may not be able to approach the court either because of ignorance or poverty or illiteracy or their backwardness. For instance, Adivasis, tribals, children, those who are in prison, like that, who are unable to approach a court of law and get relief. Any individual public-spirited citizen can fight on their behalf, and many cases the bonded laborers, prisoners, children in prison or other rehabilitation centers, victims of ragging, victims of police atrocity, unorganized laborers, denial of benefits legally due to them, tribals and Adivasis, all these people, the victims of disaster in the Bhopal gas tragedy, they all got the relief. But for this public interest litigation, vast section of the people would not have got the relief. We must be thankful to the judiciary for evolving this principle of public interest litigation. The other area, other category is where the government passes orders arbitrarily just to favor an individual. Supposing 200 acres of land is given to yaks for a paltry sum, violating all the law. Anybody going to court says, how are you concerned? If it is the old system of saying, you are not aggrieved, we will not interfere. This emboldened the judiciary. More and more such orders came to be passed where you are providing largesse to someone who doesn't deserve, even by violating the law for the benefit of, for mutual benefit, because there is no third party who will challenge this. Therefore, you feel very safe to pass any arbitrary order. Now, in such cases, the public interest litigation started giving the relief. In fact, one case which I had filed some years ago, a government on a single day granted 209 granite leases, violating every provision of law. In the normal course, nothing could have been done, but the court entertained the public interest litigation. If I am not mistaken, it is His Lordship Justice Rajendra Babu who delivered the judgment, quashing all those grants. And in appeal, what happened? The party, there were two petitions. One was by a legislator who later became a minister. When it came to a question of appeal, I was the Advocate General, I couldn't appear, and the minister concerned or the particular individual was not willing even to sign wakalat and engage a lawyer, because by then these 209 lessees have gone and approached him, and then he was not willing to. Then I had to request my junior to appear, because the other side, these 209 minors have brought no less a person than the present Home Minister to argue their case. He was a top lawyer. But my junior was able to appear, and the order of the single judge was confirmed. Of course, I am very proud to say that junior of mine has now become a sitting judge of the High Court. And then even in the Supreme Court, the said order was confirmed. One instance I am giving this is because though it has to be always public interest litigation. Now we say PIL, but in most cases, this P stands for everything other than public. My present experience, public may include, it may be political interest, it may be publicity interest, it may be personal interest, it may be private interest, it may be partisan interest. In most of the cases today, this public interest litigation is taken undue advantage of by people for various purposes. Some indulge in public interest litigation only because tomorrow they can back out after getting something from the affected party. And in some cases, it is surely because of political enmity, personal vengeance, personal vendetta, with all, and business rivals. Sometimes almost everything, it is a business rivalry. One hotel is coming up, a man in the street comes and files a petition, it will affect environment, it will happen that this, in fact in 1987 Supreme Court, case of Sachidananda Pandey, in that case, Taj group of hotels had been given land to put up a hotel, and immediately there was a public interest litigation, there was stay. For 6 years, it remained there, and at the end of 6 years, the Supreme Court gave a judgment dismissing the petition. In that it observed that they are satisfied that it has been engineered by a rival hotel group. And the contention put forward, it is close to the zoo, the animals will be affected, and the lease has been granted without following the procedure, all this. And the judges said, what is the position now in 6 years, how much escalation it could be. So today many file such petitions mainly because they know for certain that the beneficiary will come to them. And he will say, whatever it is, I don't want this litigation, because if it goes on for 2 years, my cost will increase by another 50 crores or 100 crores. This is, another is, so many development projects are affected by this. Today, if you are suffering power shortage, one of the reason is this. Even this, in Sharavati tail race project, when I was the Advocate General, there was an order of stay saying that small portion of the forest area, there are some tigers of a rare variety, they will all be extinct, and therefore the project should not come up at that area. Similarly, Cogentrix in near Udupi, the whole project was stalled because one fellow filed a petition saying that it is all illegal, there should be a CBI inquiry, and the matter went to Supreme Court, pending there for a long time. They are Russian collaborators, they said enough is enough for us, we will go away. They went. Now some other company has taken over. Now there is further agitation. So all these developments are also affected. So in the long run, today, from my experience, I can say that at least 95% of the litigation which is called PIL is really not public interest. Again, even among judges, few are very enamored of public interest litigation. Some, they won't touch it. That is the way. And the worst effect of this PIL, according to me, is the traditional litigation where there is real dispute between the parties, it has suffered. Lot of time is taken only in dealing with this public interest litigation. Please see, even if it is ultimately dismissed, 5 public interest litigations where senior lawyers are engaged and you argue the matter, how much time is wasted, and it is before a division bench. No doubt, at one stage you might remember, few years back, there was a proposal to bring in a legislation to curtail this. saying that anyone, first he should deposit 1 lakh and other things. But there was general opposition, and I am one of those who opposed that the court should be free. They themselves should formulate the guidelines to check it, and they have done. Now you can't write a letter to a ex-judge. Even if you write, it will go to the Chief Justice and it will be before a division bench. It will not be individual who will get the credit and all that. All those things are there. Therefore, the need is there to see that this does not continue for long, and this public interest litigation menace does not affect the other traditional litigation. Now, before I conclude with one important suggestion which I would like to make, I think it appropriate to read a small passage from the Supreme Court way back in 1987 about this Taj Hotel case which I said. Justice Khalid of the Supreme Court has struck a note of warning which I feel is relevant even today. He says, "My purpose of adding these few lines of my own is to highlight the need for restraint on the part of the public interest litigants when they move courts. Public interest litigation has now come to stay, but one is led to think that it poses a threat to courts and public alike. Such cases are now filed without any rhyme or reason. It is therefore necessary to lay down clear guidelines and to outline the correct parameters for entertainment of such petitions. If courts do not restrict the free flow of such cases in the name of public interest litigation, the traditional litigation will suffer, and the courts of law, instead of dispensing justice, will have to take upon themselves administrative and executive functions. I should not be understood to say traditional litigation should stay put. They have to be tackled by other effective methods like decentralizing the judicial system and entrusting majority of traditional litigation to village courts and lok adalats without usual populist stance, and by complete restructuring of the procedural law, which is the villain in delaying disposal of cases. It is only when courts are apprised of gross violation of fundamental right by a group or class action, and when basic human rights are invaded, or when there are complaints of such acts as to shock the judicial conscience, that the courts, especially this court, should leave aside procedural shackles and hear such petitions and extend its jurisdiction under all available provisions for remedying the hardship and miseries of the needy, the underdog and the neglected. I will be second to none in extending help when such help is required, but this does not mean that the doors of the courts are always open for anyone to walk in. It is necessary to have some self-imposed restraint on public interest litigants. Ultimately, by dismissal of this appeal, the hotel will be completed and will be commissioned. 6 long years have passed by. I do not think that the appellants have achieved anything. The first appellant, who is a trade unionist, has not espoused any grievance of Mazdoors before us. It was faintly suggested by the government counsel that the first petitioner does not represent all Mazdoors. This was refuted by the appellant. For the purpose of the case, we will accept the assertion. We do not have before us any of their grievance ventilated, which, if there were any, we would have willingly considered. And I conclude this short judgment with a lurking doubt in my mind and with a question: is there something more than what meets the eye in this case? That it is engineered by another hotel group, I don't wish to mention its name. This is how the Supreme Court dealt with the matter. Now, before concluding on the question of public interest litigation, I submit that the lawyers have a great responsibility to see that such frivolous petitions are not filed, even if it is a case where the party may pay heavy fee. In fact, public interest litigation is supposed to be by a poor man who has no means. But actually, we find topmost advocates from all over the country appear in such litigations. I'll be failing in my duty if I don't quote one instance, very recent instance, not more than 5 or 6 months back. A division bench of our High Court granted relief to a public interest litigant. I have got a copy of the judgment. That litigant says, I learned from newspapers that these illegal iron ore mining is going on in the state, so I am filing this petition. The relief he seeks for is that all the big steel industries in the state are suffering because leases are not granted to them but is granted to others. So you must give priority to those industries who have already invested and are running the factories. Give them priority. Lay down all guidelines how they should be given priority, how the central government should dispose of their applications within a period and all that. And a senior counsel from Delhi comes and argues, and all the reliefs sought for are granted. Now the relief is in favor of all these steel industries in the state. Are they the people who are unable to come before the court of law and should engineer a litigation through yucks? The courts must be alive to this. Such petitions must be dismissed at the threshold. And sometimes even judges find it very difficult. Senior lawyers appear and argue they can't shut them. Therefore, one suggestion I am making is, in the case of public interest litigation, no litigant has a right to say, my right is affected, you are bound to hear me. It is a question of discretion of the court. Therefore, just as they do in the Supreme Court of United States, no citizen has a right to file an appeal as of right. Of the thousands of appeals that might be filed, they select 200 or so, which is to be heard in the course of the year. Like that here, at least in respect of now public interest litigation, supposing a committee of judges is constituted with His Lordship Justice Bhattachala as the chairman, they will scrutinize and easily with their experience they will find out whether it is a real case where the grievance of the public is being vindicated or it is a petition filed for. If that is done, even if it is a case of 4 or 5 cases per day, the precious time of the court spent in open court is saved. This is one suggestion which, in all humility, I am making with the further observation that we, the lawyers, also have a great responsibility to see that frivolous public interest litigation petitions are not filed. Thank you very much. Thank you for a very patient hearing.
You can answer the question sitting. I will give a mic. Friends, those who have relevant questions can come to the dais and be brief on your question. Don't start a debate. Come one by one.
I am Dr. Venkatesh, professor at Vijaya College. In your earlier part of your essay debating on judicial activism, you were commenting about the need of judicial activism because the executive and the legislature sometimes is lethargic in performing its functions. But 2 or 3 cases where the legislator has crossed over to the realm of the judiciary, particularly the Shabanu case where it was overturned, and now the Alini case where it is pending whether she is being pardoned or not. And what is the view of you on clemency also? Because clemency also comes under the presidential pardon, which is again the office of the president itself is for the last 5 or 10 years being questioned in the mindset of people.
It is the settled position that judges only give the judgment depending on the law as it existed then and as they interpreted it. But if the legislature finds that the law has not been properly interpreted, it is open to the legislature to enact a new law by taking away the basis of the judgment and then even validate those acts which have been struck down. This being a accepted position, you can't find fault with the legislature if it enacts a new law which has the effect of nullifying the judgment of the court. Only restriction is if it is a judgment inter partes and binding on all of them and it has become final by mere law, you can't take away the effect of the judgment. The binding decision will stand. The law newly enacted will apply only for the future.
My name is Hari Rao. I am from NR Colony. I am a retired person. Sir, is it not time that Article 21 is diluted and mercy killing is allowed under the scrutiny of some advisory board or judiciary, because there is so much of suffering in the country due to incurable diseases?
No, it's all a question of personal view, what they call euthanasia. And in, I think, very few countries, this is permitted, that is mercy killing. But generally it is not accepted. If you are asking for my individual opinion as an individual, I fully agree with you. At least in appropriate cases where you see a person suffering, living like a vegetable, it is not worth living. In fact, I have very strong objection for the doctors nowadays. What they say, they don't allow you to live, they don't allow you to die. Even when you are about to die, you are put on a ventilator, and it becomes very difficult for the relative to say, you remove the ventilator, because you know the consequence. So personally I agree, but it is a larger question. It doesn't depend on Article 21.
I am NSS Murthy. I am a retired person. I want to know, sir, whether we have got rights to nature and environment, like forests and rivers, like we are having fundamental rights to citizens. Because we feel that as we are going on, we feel we are becoming too materialistic. That's what we learn from the lectures at Gokhale Institute. I think, is it not high time that we should have fundamental rights to all the nature entities? That's also my question.
I think those fundamental rights are already implicit, and in fact the Supreme Court has evolved it and has given several directions with regard to environment. In fact, you might remember some time back, in respect of some resort which was living affluent to the river, polluting the area, the Supreme Court levied a fine of 50 lakhs on that industry. In fact, they have developed the law to such an extent that if that type of pollution continues, the liability will be not only of the industry but also of the government, which has allowed it to happen.
Now we have come to the presidential address by Honorable Justice Bhaktavatsala.
Good evening, all of you. Dr. B V Acharya, Justice Puttaswamy, Mr. S.R. Ramaswamy, the Honorable Secretary of the institution, ladies and gentlemen. It's a great pleasure that I am here among the intelligentsia. At the very outset, I want to pay my respect to the founder of the institution, and I thank the organizers of this function for giving me an opportunity to preside over this function and to listen one of the legal luminaries of the country, Sri Dr. B V Acharya. He did his law when he was at 1956. I was just a 4 years old child. So I cannot be compared with his speaking, learning, acumen. And one more thing, I have not prepared anything. When he was addressing the August gathering, I was just recollecting. So my job is made very easy because presiding over the function. And apart from that, I got some problem with the throat. However, it's my duty because just Puttaswamy and Mr. Rangaswamy, they came and requested me about 1 month or 2 months back that this is a program, so that I don't want to escape. So I made it a point to be here, and also this is the first time I am visiting the institution. Though I was teaching in the APS college for nearly 1980, that is June, July, till my appointment as a district judge. So I am well conversant with thing. Only thing is I did not see this much of development. I can see lot of development and very good get up and look for the institution. I never entered when I was teaching here. Anyhow, as far as the topic is concerned, it's a very nicely coined judicial activism and public litigation. Some of the aspects refer to about appointment of a judges. That is a controversial subject, and everybody is. Dr. B V Acharya said his junior also has been appointed. I think Mr. Arvind Kumar?
No, Yajji Ramesh.
Yajji Ramesh. Yajji Ramesh, yeah. Yajji Ramesh, I know, yes. Now, that's also appointed by a committee. If that committee collegium was not there, he would not have been appointed. There are always certain advantages and disadvantages. Now, I will have to refer about the division of powers. Now, what are the powers? The powers of the state have been divided. First is division of powers. Then we see about separation of powers. There are two aspects. Division of powers is one, then separation of powers. When division of powers is concerned, there are three divisions: legislative, executive, and judiciary. So, among the three organs, who is supreme? Nobody is supreme. It is the Constitution is supreme. Constitution, Indian Constitution is supreme. Then we are in the 61st year of Republic year. This democracy survives because of whom? Is it because of the legislature, because of the executive? No. If there was no judiciary at all, the democracy would have collapsed long back. I would compare the democracy with reference to a bird. You know, bird means there will be two wings. One wing is executive, other wing is legislature. Now, when the bird goes straight, if both the wings are proper and flying, it will go straight. If let us suppose one wing is there, then it will turn like this, then go back. The democracy also like this. If both the wings are correct, then go straight. It's in the right path. If one of the wings, either the executive or the legislature, is not doing their form, there will be some defect. Who is curing? The doctor treats the patient. We judiciary is treating these two persons. Judiciary is treating these two. Whenever there is any defect, error, like curing the disease, we cure the defect. That is the reason why we have this democracy still survives. It will go a long years to survive, and there is no doubt about, so long as the judiciary is powerful and independent of judiciary is maintained, the judiciary, the democracy in the country will survive. It will be one of the excellent democratic country in the world. And our judiciary also is a very important judiciary in the country, in the world. Everybody is jealous of our judiciary. Now this appointment issue, judicial activism. Activism means what? Now there is a RTA activist, right to information activist. There is other activist. That is fundamental activist, civil right activist. There is no judicial activist. We judges perform our duties in accordance with the Constitution and the principles laid down. So we don't call ourselves as judicial activists. If at all any judgment is rendered, we are only interpreting and discharging our duties as a judge. So there is no activism. Only others, those who are seeing our activities, they call it a judicial activism and activist. In my view, there is no such judicial activism at all. The judiciary is only functioning as it is. We do only our job. There is no place in judiciary to make activism. There cannot be any judicial activist also. It depends upon person to person, the knowledge, acumen, experience. All these things play the role when a person delivers a judgment. If a person doesn't have experience, he doesn't analyze the situation, he will not give a good judgment. When a person applies his mind and delivers a judgment, interpreting everything, so judgment is appreciated. This is, there is judicial activism. Now, what they were doing when the courts were setting aside every legislation made by the legislature, parliament and state legislature, even some of the agrarian laws, what these people invented a way, they created a 9th schedule. What they did, they make a law and put it to the 9th schedule so that nobody can touch. Now, about 2 years back, before His Lordship retired, Chief Justice retired, he said even the enactment included in the 9th schedule, 9th schedule or 7th schedules? 9th schedule can be tested with our judicial review can be there and with reference to the fundamental right. So this is the application, the latest. Now everything is taken and put it to the such a thing like a strong room. Nobody can touch, nobody can do anything. So that judiciary has done it. Even then such a legislation, such an enactment can be looked into whether it is in accordance with the fundamental right or not. How laws are made? Laws are made in a state by our legislator, our representatives. And when state law is made, when comes to one judge, he holds it is unconstitutional with reference to the law of constitutional law, one man. Law is made by so many persons with debate, upper chamber, lower chamber, all chambers. Ultimately, by one judge, he strikes out. That is the power of the judiciary. So, the acumen of the judge, it's not like just like that. So, judges are appointed. Judges are appointed with there is some experience and he is capable of doing. That's what because nobody can make out whether he has got stuff or no stuff. But only observing. As far as the service judges are concerned, they can see everything. I was a district judge for 14 years. 14 years who went? Then I am working so now the advocates who are practicing, they will just say yes, how he presents argument, how he articulates. Like that the persons are picked up and appointed. So this judicial activism, in my view, only others they call it as judicial activism, but we judges, we don't call as we are activists, we are only judges. We are obedient servants of the public, general public, that's all we can say. So when we interpret now, the reference was made about transgressing powers of others. There are so many treaties, they become law. That means neither the parliament makes it, but when the treaty, foreign treaties, they become a law. There are certain treaties between our country and a foreign country. They agree for something and they don't make a law. But still, treaties will have the force of law under certain circumstances. Now, there are two instances were referred to. One is with regard to giving directions with reference to Vishaka case, Vishaka versus Rajasthan, state of Rajasthan. I think that's what decision I wanted to see. It's a AR 1977, 97 or something, the decision. In that case, you know how the directions were given. That is with reference to Article 14, 15 and 23 of the Constitution, the decision came to be rendered. That is with reference to women and sexuality, working women sexual. Then in that case, they were least bothered. The parliamentarians and the legislatures didn't bother about it. So that it is ultimately the judiciary took the task. Asked the Attorney General, yes, gave certain things. After due discussion with the Attorney General, the Supreme Court has laid down the direction. These directions will prevail until they make a law. So it is not that judiciary itself is this. Attorney General is the person representing the union. He has agreed with his approval. When he approves means what? Government is approving it. The executive is approving it. So then law is made. Then regarding judges appointment case, now I want to say, Dr. B V Acharya made a thing whether I agree with him or not. What I see, whenever appointment is made by the government, earlier process, and in my thesis about the constitutional development through judicial process, I have referred about it. There are judges case 1, 2, 3. There are 3 cases. Not 1, 2. 3 cases are there with reference to appointment of judges. In that case, the independence of judiciary is the most important thing. This is with reference to doctrine of separation of powers. Now, Chief Justice is the head. We have got a unified judiciary. But there is no unified laws in the entire state, entire country. State has got certain laws and other state has got certain other laws, and with reference to union laws are also there. So there is a unified judiciary, but we don't have unified laws, uniform laws. But now, under such circumstances, when judges are appointed, if the government has got anything, what is the role of government? We don't do anything with the reference to the government. It is our judiciary. We know who are the persons suitable. If it is given government, what they will say, they will know whom are interested in the government, they do it. The government should not have the role. Now maybe because, now we see that the system is working well. Maybe always there will be, no system is for 100% correct. There may be some defect or something, application. So merely because of that, the appointment of judges, what's going on is right. Otherwise, if the government is given, government will have the government role. Whether this government, they will push their people. If that government comes, they will push their people. And ultimately the, the memorandum war, you shall not have any affiliation to the government. Any person appointed as a judge, you should not have any affiliation to any political party. Now, with reference to the High Court, see, 3 judges collegium. With reference to Supreme Court, appointment of High Court judge, 3 judges. Appointment to the High Court, Chief Justice and Supreme Court judges, 5 judges, senior judges, including Chief Justice. It is the judiciary which knows what is happening, how judgments are dealt with. What is the government knows? Government gets some information from the IB. Whatever the person he writes it, that is the report of the government. No, the judiciary now having seen the judgments are read, there is some other report maybe. Sometime now they wanted to publish this, the judges appointment file. And just as Rajendra Babu said, then they will be put to wolves. It is not, see, because some record will be there, it will be exposing the persons. They said, why should anybody say anything against a person who is doing very well? A judge who is doing very well, why should any judge come in the way? If at all is some, now let us suppose recently, just as AP Shah from Delhi, he retired, and you can see the website where internet, how they appreciate. He has rendered a very important judgment on sexuality, homosexuality case, and where right information, even office of the Chief Justice is open, is not, no privacy, nothing. Yes, open, he rendered judgments, and say he has sent home, he has not been elevated to Supreme Court. One thing I will tell you, whether elevation or non-elevation depends upon one's fate. There is nothing. It is, if he has got a fate, he will definitely get it. When I was number 2 candidate when I was gone for interview, district judge, I said, let them put any number of questions. I myself, my mind said, yes, I will be selected. Because I was teaching, and also 5 judges questioned me, I treated them as my students and answered the questions. Yes, I did not have any fear. The first man, I was number 2, first man, Mr. Purushottam Rao. I was just inquiring, where is he, that very FT man and all. He went inside the chamber. I thought he will take another half an hour. Within 10 minutes he was out. Then I was made to wait there. Then I went and I was interviewed for 45 minutes by all the 5 judges. All the 5 judges put me questions. And Justice Rama Joyce and Chief Justice put 2 questions. And I think Mr. Justice Nesargi. Only Chief Justice put 2 questions and Rama Joyce put me 2 questions. So like this, it is performance. Now they are conducting written test for selecting. There are certain defects there also. A person who is able to present, he may not write. So we will only get only professors as judges. Now what's going on? Now we are conducting test. Just Ravindra sir laid down. So test now by interview one can make out what is the stuff. Give assertion, that is you give your income, we can make out what is your experience in the bar. I had maintained account from the day 1. My first month income was 45 rupees. After I became an advocate, my senior, he never used to give me. He used to give me only whenever he is not regular, like I was not bothered about, but he used to give me work. Take this well, go and do whatever. So this judicial act, what I am saying with reference to appointment of a judges, one should have fate. If fate is there, he will definitely get it. Whether government is, what is the government role? You are only appointing authority because you are giving money, perceive with you, see it is what we are doing it. What we are doing, take note of it, that's all. Now, who has to be elevated, who should not be elevated, making allegation, this thing, that thing. Anyhow, I have, this is my opinion, I am not having anything, it's my understanding. Every Article 21, I am going to refer about what is Article 21. When I started addressing, I think my throat has become normal now. So this is appointment, it is independent of judiciary. Every judiciary in the world is jealous of our judiciary because ours is a very powerful judiciary, we have it. Because of this powerful institution, our democracy survives and people are saved and our country is protected by public interest litigation. What we call, that it was a public interest litigation was earlier called in America and all, social interest litigation. We call it social interest. It should be social interest. And Justice Bhagavati was the person, he is the father of this introduction of this public interest jurisprudence. When we make jurisprudence, new jurisprudence, they say judicial activism. Jurisprudence we create, we think about what is happening, how it should be then. Otherwise there will be people will be at fault because the ministers, everybody is bothered about their own share, what will happen tomorrow, they don't know. They don't have time to think. But we have got certainty, definite. Our salary cannot be reduced except during financial emergency. Except our salary cannot be reduced. Our judiciary is very strong and protected, independent judiciary we have. Because ours is until our retirement, impeachment. Impeachment, we know what's happening and all. I don't want to touch about that, such a sensitive. Now, this regarding appointment, I view, if the persons in the helm of affairs are good, selection will be good. If the persons in the helm of affairs are not good, maybe some pollution, air pollution, appointment pollution, or some other pollution. So, we have pollution. Now this judicial and Article 21, what happened during the emergency? You know, Justice Khanna was treated as a person Though he wrote a minority judgment, he could not become a Chief Justice of India. He has got a statue for having rendered in DM Jamalpur case, District Magistrate Jamalpur case. He rendered a wonderful judgment. Their judiciary is there. Judiciary is not after the post, not afraid of the government. We are afraid of only the Constitution, preserving the Constitution. This is a very important sacred document of our country. Such a wonderful document we have, having done PhD with this constitutional development through judicial process. Really, I thought that LLB is okay. After doing LLM, I said, no, after doing LLM only knowledge will be complete. Then, after doing PhD, I said, no, only of LLB, LLM, no, only doing PhD, knowledge will be complete. Now I think, only after doing LLD, some knowledge I will complete. I will not be complete. 100% nobody can be complete. Nobody can. I used to tell our judges who were selected and being trained now, 25 marks when as a law graduate, 25 marks as a training in the judiciary. You advocate, you will get 25 marks. So you are second class student. When you join judiciary, you will get another 25%, 25 marks by delivering judgment, hearing, disposing case, 75. Then 5 marks, our judicial academy gives you 5 marks by giving training, 80 marks. Then you don't expect 20 marks because it will not be there. Nobody can become perfect. So this is how we are now selecting judges. There is a selection process. We are now, earlier some method was adopted, now they are adopting for district judges for this. In my view, I have got to say, we should have the career system of judges. Career system means start from the beginning. There shall be a career college like this. If one wants to become judge, yes, start with that, go to the college, have the training, how a judge should behave, how a judge should conduct, how he should behave from the beginning, he should be trained there. Then appoint him as only a judge. Then he should be taken. So this question of appointment of judges will go, this collegium will go, government will have no authority to do it. But now in other countries, in other foreign countries, we have this career system. And now here we pick up judges. Now there is a combination, they say, combination of bar and bench. Where is the combination of bar and bench in Supreme Court? No. They select only the persons again. There is no combination there. Nobody asks about it. Now the cases are income tax cases gone, service matters gone, and railway tribunals gone. Everything is gone. What remains? Only the cases coming from the judiciary, that is the subordinate judiciary, district judiciary, we have it. But still we have this ratio of, that is what you say, 33% and remaining is from bar. And I don't want to comment because I'm in the part of the system. I have been seeing it. What the judgment somebody writes may not be correct for me. What I do it for may not be correct. But in my view, there shall be a good training for the judges before coming to the court. Otherwise, after appointment, you know that it cannot be removed very easily. It's very difficult. And because of that, people think what happens if you have a milk and put 1 drop of poison, whole milk becomes poison. So allegation is again the attribution is again the system. Even if 1 person, 2 persons commit something wrong or doing something. So we should have that kind of system, preserving the institution should be preserved. The person should be like that only. Judge means judge not only in the court, even outside. Even when he deals with his own matter with his family, he should be a judge. So this kind of approach should be there. Now, you know that Article 21, it is any person, even foreigner will, when he comes to India, he will have the right of Article 21. Even now, because of the amendment during Janata Dal period, they have amended, even during emergency, Article 21 cannot be suspended. Article 21 remains. You have got right to your personal liberty even during emergency is proclaimed. So this is with reference to judicial activism and appointment of judges and all. See, something I said, Constitution is perfect. Now there was a committee, just Venkatachalaya was appointed, head the commission. I used to tell, there is no need to amend the constitution at all. Constitution is perfect. Only the mindset of the people should be changed in the helm of the affairs. Mindset of the people should be changed wherever the persons are in the helm of affairs. The judges, the parliamentarians and the executive, they should change the mind. Our constitution is so nicely drafted, it will survive for thousands of years, and there is no need to amend anything. Only thing is because of now what's happening, you join one party, you win, after some time you vacate, go and contest, and you go to some other. This kind of election reforms is required. So there we should do something. But we should now, our money and people are, after this election, we are ruining, our country is being ruined in the form of election. Election is required. How? Once you elect, you forget about the party. No, only thing is, only for election. After election, forget about the party. Person should have the right to work for another 5 years. Now, he leaves it and goes and joins. And he becomes minister. Afterwards, if he doesn't elect within 6 months, he loses the seat. This kind of system in the country, really, I don't know. Really, I feel sorry because I don't know whether any press is here. I don't report all that. This is my view. And I really, because I am also a human being, I said, after judges we become judges. We have no justice for ourselves. We are giving justice. I used to tell, judges have no justice. We have no equality. We have no right of Article 21 and 19. So we too have something. But sometime when the matter comes, usually that will have some effect on the judgments what we give it. Always, we can't keep judge one thing and application. Always, whatever the learning, the experience, everything will have reflect in the judgment. If you read the judgment, you can make out what kind of judge is, what is the approach of the judge. What is the approach of the judge? So, in my view, judicial activism is nothing but, there is no such activism, no such judicial activist. We are only discharging our duties in accordance with the constitution of law and the oath we take it. With reference to publication litigation is concerned, as we say, this is developed for the purpose of poor, weaker section of the people, poverty-stricken people, bonded laborers, where there is a pollution control, where there is a destruction of forest. Now, Godavarman case, if you go and see what Supreme Court has taken it off, so many orders have been passed. Almost all the states are parties. Even our Karnataka, when I was a law secretary, I have seen it. No question of this mercy in protection of wildlife and forest. It's doing it, but they are misusing it. How they are misusing it? You give the knife, you can cut apple. Also you can pierce if you want to murder a person. That's how it's happening now. Things are good, but how the person utilizes the thing is the other way. So they are misusing it. It is either publication litigation means there are certain authorities now. Because of the authorities, there are certain principles of certain persons, bonded laborers have been released. The people we did not know in Kolar and other side, they were kept for many years. That's a good theory, but it should be utilized for a right person. It should not be paisa vasul. It should not be political mileage. So now Supreme Court has laid down the guidelines now. Interest publication litigation cannot be just like that. Supreme Court has laid down how a publication litigation should be entertained. Once a publication litigation is filed, he cannot withdraw it. He has no right to withdraw. That is a law laid down by the Supreme Court. He can't withdraw it. He has no business. He cannot come, he cannot walk out as an visa. Once he comes, that's all, finish. As we pay money to the income tax department, gone, it's like that. So, publication litigation is very important because poverty, ignorance, illiteracy, downtrodden people, that's why Legal Service Authority Act has come. Because you see now how the things, then let us suppose there are A and B, a plaintiff and defendant. If plaintiff has got more money, he will definitely engage an advocate, senior advocate, Dr. B V Acharya, and he will definitely use his brain and pay the money and use it, he will win. What about the defendant? If he is a poor man, he will not get engaged in services and all. What is that? Some poor advocate, poor client, poor advocate, like me, as I was. I would struggle like in my life. I used to come and teach this college, go to PES college in the 2 days, Friday and Saturday. I told Mr. Narasimharaja Naidu, if you are giving 500 rupees salary, I will come. Otherwise, I will not come. Here I was getting government salary, APS college. There I was getting only, it was not aided at the time. You give me 500, I will come. I will come only on 2 days, that is Friday, Saturday afternoon. And I was teaching other colleges. Getting money from the client is very difficult. Sometimes we have to tell lies. I didn't want to tell lies. That's why I became a judge. I used to tell. Other day I went to Bellary where I inaugurated one court in Agribomanalli and another court on the same day in the afternoon in Kodligi. I said, why I become a judge? I don't want to tell a lie and collect the fees. Because if you tell 1,000 rupees is the fees and 500 rupees, expenses, 500 is fees, you will give only 1,000. Sir, 500 rupees, where I am going? I am here only, I will give you that slowly. Then how advocate can survive? So there is a lot of problem in every profession things. And I was asked, because I did my BCom, LLB while working as I was writing accounts, I was working in HMT Industrial Estate. Then Justice Nesargi, he was number 2 or 3 judge, because Justice Jain and Justice Ramajo is Justice Nesargi. He put me, you are an accountant. I had mentioned that I was an accountant. You are an accountant, you want to become an advocate? Yes. Now why you want to join judiciary? Yes. I said, I want to serve the society. I remember all the questions put to me. I stick on to that. I serve the society. With great dedication I am doing it. So people were to have that mindset and do it. And when the other day, one interesting litigation came. Myself and Mrs. Justice B V Nagaratna, because division bench matter came. What is that? One person about 20-25 years given land for the purpose of construction of a school. Then 1980 onwards, the government has made a notification. If anybody gives land or 25% of the cost of construction of the building, the donor's name will be there. After that is school name. That is, the donor's name will find the name of the school. That time there was no notification. Then the legal, that is the family of the donor, requested the government, please put his name. Then they put it. The donation was made earlier. They put it notification. They put his name, recognizing a donor's name. There was a public litigation before the vacation court. It was on 30th December or 31st December, because I sat 29th or 31st. These 2 days I sat a vacation bench and she was sitting with me. And case is public litigation. I said, what is the public interest? What do you mean by public interest? What is the public interest you have? Merely because of naming they say is a public interest. No, if it is named after, no other person will come and contribute any money for further development. I said, you don't recognize a person already donated the land. You have constructed a school. Now recently they have constructed a school. Not that the land was given. It was with the government education department. Now they constructed a school. They recognized his name. I said, first you recognize the person. First of all, how the writ petition is maintainable as a PIL. I rejected. I also ordered to report. What is public litigation? I have mentioned it. Only the people, there should be some interest. Not interest in naming and all. I have mentioned with reference to what is public, I have defined it, what is public litigation in that. So it will be reported in ILR, because I have already marked to report. I don't know when it will be reported. So what is public interest? People don't know. As Dr. B V Acharya put it, there is a paisa vasul litigation, enmity, or because he is not getting the land, others should not get it. Dog in the manger policy. We call it a dog in the manger policy. Neither you get it nor allow him other to get it. So that is, we call it dog in the manger policy. Then paisa, that is political mileage, to gain political mileage, to become a politician. These all things. They always, system is good, things are good, but people are misusing it. Now for example, Dowry Prohibition Act and dowry deaths. Some death will take the attached dowry. We have not only that, entire family members. So these all things going on in the country. We'll have to, our judiciary is there to take care of what is right, what is wrong. To some extent, we apply our knowledge and acumen and experience, see which is correct, which is truth, which is untruth. That is our duty. Duty of a judge is to find out which is truth out of which is untruth. So this separation is called our duty. I think I have taken much of a time. I was told only 10 minutes. I don't know how much time I have taken. Anyhow, my throat has become normal little. So I thank you all of you for, I think I am in the member of intelligentsia. I can make out from the face is the index of the mind. Everyone has got rich experience. Before you, I am a small man. I have given some few thought of mine. And if you accept it, accept it. Otherwise, don't comment about me or don't go to the press and say anything. And once again, thank the organizers and Justice Puttaswamy. Artist Sage came to my house and chamber and requested me and came. Really, I am beholden to him. Good luck. Wish you all the best. Thank you.
Friends, without wasting more time, one announcement. On 27th Saturday, we have a talk by Shri T.R. Anantharamu, a scientist from the Indian Mines and Geology Department, on science and social values. It will be in Kannada, named Vignana Mattu Samajika Maulya. All you and your friends are cordially invited. Now we have vote of thanks by Justice S. Puttaswamy. One more announcement. We have found a car key in front of our gate. Please check for yourself. If anyone of you have lost, give the identity and collect the same from me.
Dr. B V Acharya, Dr. Bhaktavatsala and my friends. Mr. S.R. Ramaswamy, who happens to be the General Secretary of this organization and who generally offers this vote of thanks with a great erudition, is unwell. Therefore, I have to perform the function of a welcoming.
I am also unwell.
I have to perform both the functions of welcoming the distinguished guests, speakers, and also the vote of thanks. Of course, Mr. B V Acharya asked me why a lawyer should have been chosen. I may plainly tell you, I had seen him arguing his cases before me, at least for 8 or 9 years. I had found him to be one of the best exponents of law before the courts. And I knew also he is keeping his, razor's edge always sharp. That is, a lawyer's razor's edge must be very sharp. Now I don't have that sharpness because I have lost all contact with law, particularly with law. Now I don't have that razor's edge. I knew Dr. B V Acharya is keeping his razor's edge always sharp, and he is the best person, though he is a lawyer, he is the best person to speak on these two difficult subjects. It is, many are under the impression this judicial activism, public interest litigation are very easy subjects and anybody can speak on this subject. It is not so. You have heard Dr. B V Acharya with his rich experience and experience has given his profound thoughts on both judicial activism and judicial public interest. Why I chose Mr. Dr. Bhaktavatsala, of course, it is not my only. Myself and S.R. Ramaswamy, we sit together, we choose the persons. And S.R. Ramu, who is the joint secretary. We always make a lot of thought. You must have seen, for 6 months we drop our program. For 6 months, from January to June, July to December. So it is a very difficult task. In that difficult task, I also assist them to the extent I can do it. And that is why when Dr. Bhaktavatsala said, I have to go to Gulbarga, I told him, Dr. Bhaktavatsala, this we consider as a holy hall. In fact, this Dr. Gundappa Sabhangana, we consider it as a holy hall. And everyone who gets an opportunity here consider himself lucky to be come and participate in the function. Therefore, I persuaded Dr. Bhattachala to cancel his itineration to Gulbarga, but he now told me in the he has to suffer in the worst summer. I am sorry for that, Mr. Dr. Bhattachala, but I assure you that you told me that you have not entered. You have entered, and I wish you go and see the library also, one of the finest libraries in this Bangalore. And as a judge, I may tell you, I had a very difficult case to decide about some caste matter reservation. I forget all that. Mysore High Court had one of the best libraries. I mean, Maharaja's High Court had one of the best. But I found that library also did not provide all the books. Then I thought over the matter. I came to this institute, and with great difficulty I was able to get that particular authority to write a judgment on that. Dr. Ramajoyce told me, who had appeared for the petitioner in that case, and he later, I didn't mark it as for reporting. I don't know why he asked me, where did you get all this? And he asked me, you have written such a good judgment and you have referred to all the authorities. I told him I had to go and do research in the Gokhale Institute of Public Affairs. There I was able to get the information I did. For your kind information, sir. I also happen to be a member of the Environmental Protectional Institute. Dr. Shiv Shankar, who is here, he is the president. I am also happen to be connected with. I am now connected with this social organization. Thank you very much. Every one of us have been benefited by your learned lectures, and certainly we sincerely thank you for your sparing some time and sharing your thoughts with us. Thank you, sir.